Convict, the Honorable Agnes Nandutu, is hereby sentenced to imprisonment for 4 years, contrary to Section 21(1) of the Anti-Corruption Act. The period that she spent on remand will be deducted from the 4 years that I have prescribed, and this date runs from the date of conviction. All the iron sheets that were recovered, there are 1,585 as per the count of court on the 9th of August 2024, shall be returned to the office of the Prime Minister to which they belong. 3, I issue an order that bars the convict from holding any public office for 10 years from the date of her conviction. I hereby order that any amounts that she deposited for bail is hereby refunded, because bail has now served its purpose. All the sureties that stood for her are accordingly discharged, and any securities that were deposited for her bail are to be returned to those that deposited it. I have declined to give the option of a fine. I have given the option of a custodial sentence alone. I don't know if there is anything that you'd like to state, Counsel? No? That the convict breached the public trust and that the offense had a significant impact on the community. All the aggravating factors for a corruption offense that are listed in paragraphs 42A, 42B, 42C, 42D, 42E, and G have been exhibited in this case. The aggravating factors listed in paragraph 43, namely a corrupt intent or knowledge of the effect of the crime, B, the abuse of office for personal gain, and C, the prejudicial nature of the corrupt act, and then H, whether the act was committed in respect of essential goods or services, have all been established in this case. When I look at these aggravating factors, I find that they outweigh the mitigating factors set out in paragraph 43 and those that have been raised by the accused and by the defense, which I have listed in. The only saving grace is the public apology rendered to the appointing authority, the people of Karamajong, and the public at large. For the reasons above, I decline the request by counsel for the defense to impose a fine alone. The reasons for this is as follows. The highest penalty of a fine prescribed under Section 21(1) of the Anti-Corruption Act, which is the penalty for this offense or a fine, is 160 currency points, and comes to a paltry 3,200,000 shillings. By all standards, that amount is inadequate, and I, at this juncture, wish to state that it may be useful for the legislature to consider or reconsider the ranges of fines that are prescribed in the law for corruption offenses. In my view, they are so low that they make it difficult to hand down to convicts in corruption cases. In fact, the convict often cannot benefit from the sole option of a fine because they are so low that they do not fit the crimes. And one of the principles of sentencing is that the offense, the sentence that is prescribed by the court must fit the crime that has been committed. So, the sentencing guidelines recommend a starting point of 3.5 years for the offense of abuse of office. I will use that as a guide for the offense of dealing with suspect property, for which no ranges are specifically provided. Now, since the aggravating factors outweigh the mitigating factors, and since I have already said I cannot render a sentence of a fine alone, I can only move upward from the starting range, which is 3.5 years. I'm of the view that the 5 years prayed for by the state is on the high side, considering that the iron sheets eventually were recovered, though they are no longer new and had been kept somewhere in a certain state. The missing iron sheets have been paid for, and the convict is remorseful. Also, the fact that there was a lack of premeditation. I therefore find that a sentence of 4 years imprisonment is suitable in the circumstances of this case. Compensation orders are intended to provide immediate relief to victims of crime and alleviate the grievances of complainants. In light of what I have stated about the recovery of the iron sheets, I decline counsel for the state's application for me to order a compensation order. I also wish to state that a compensation order ought to be based on clear evidence of the loss that has been suffered. If the iron sheets have been now recovered, and as I'm going to order, should be returned to the government, then the compensation order, I think, does not fit the purpose. So in that respect, I will decline to issue a compensation order. And therefore, order as follows. But before I do, can I have from prisons evidence of how long the convict